Welcome to day 2, everyone. Glad you guys were able to come. We have a pretty pretty interesting lineup for today. So pretty timely information also. Our first speaker is Mr. David Fatui. David Fatui is a partner in the Washington, D.C. office. He practices in the firm's litigation department and is a member of the firm's environmental litigation and mass tort practice group. Mr. Fatui joined the firm after nearly 4 years of U.S. Environmental Protection Agency working there. He served as an acting general counsel, principal deputy general counsel, and deputy general counsel. In 2021, National Law Journal recognized Mr. Fatui as a trailblazer in environmental and energy in law. And Law 360 named Mr. Fatui a rising star, of which is still happening. So, after the stint at the EPA, led the office of 245 attorneys and staff. He played a critical role in developing a litigation strategy to defend the agency's actions from judicial challenge, including leading successful efforts to define the Navigable Waters Protection Rule, EPA's Risk Evaluation Rule, under TSCA, EPA's decision not to impose Superfund financial assurance requirements on the hard rock mining industry, EPA's 2017 annual volumetric rule under the Clean Air Act. And I can keep reading this because it goes on and on, and it's amazing. So you guys are blessed to listen to my man, Mr. David. So I'll let him talk.
Thank you, Brian. Well, good morning, everyone. Pleasure to be with you. Really great to be back at 4C, and goal this morning is to leave you all with an overview of the regulatory developments that are going on at EPA right now. Sort of give you an update on recently finalized actions, talk about some actions that have recently been proposed, and then give you a preview of sort of what's on the horizon. We only have 45 minutes, and I want to leave time for questions. So this is really a survey of what's on the landscape that's relevant to the industries that are represented here at this conference. So we're not going to go extremely deep into any of these, but I want to give you a broad overview and give you a sense of situational awareness of what's going on. So as Brian said, I'm a partner at Gibson Dunn in DC. My practice is focused mainly on enforcement defense and investigations, as well as helping clients through the regulatory process, the rulemaking process, and then ultimately challenging agency final actions if the outcomes are not what our clients expected. So that's a little bit about me. I won't spend too much time on it since we've got really interesting things to cover this morning. So like I said, I'll start with an overview of regulatory developments. I'll spend some time on enforcement, and then we'll go to questions at the end. Let me start with some recently finalized actions that I think are relevant to folks in this room. Last year, in the first year of the Biden administration at EPA, the agency spent a lot of time on mobile source regulation. So they proposed and finalized new standards for light duty cars and trucks for greenhouse gas emissions. And I think there are signs from this rulemaking that may be applicable to certain actions that are coming down the pipe. So the standards revise the GHG emissions requirements for model years 2023 through 2026. It's a reconsideration of a rule that was promulgated under the last administration. What's interesting is that they, you can see on the graph here, the finalized standards, which are a solid line, are more stringent than what was proposed. So the agency took comment, as they're required to do, and then ended up finalizing the more stringent alternative that they had included in their proposal. It has some pretty optimistic projections about technology penetration for mild and strong hybrids, as well as battery electric and plug-in hybrids in terms of the percentage of the market, and uses those assumptions to set standards. So I think the willingness of the agency to finalize the more stringent alternative here in the face of environmental NGO pushback on the stringency of the proposal, I think could be an indicator of what they may be looking at in other rulemakings down the road. Just recently, let me touch on this as well. They issued what's called the California Preemption Waiver. The Clean Air Act has this sort of unusual provision that allows California, but no other state, to set its own emission standards for mobile sources, but it needs a waiver, a preemption waiver from EPA to do so. EPA had granted California a waiver in the Obama administration to set its own greenhouse gas and zero emission vehicle standards. In the Trump administration, that waiver was withdrawn, and then now it's been reissued. So California now has authority once again, if it chooses to implement its own more stringent GHG standards. Now, whether they will go more stringent than the already pretty aggressive standards for this period, I think is to be seen, but that has been sort of reversed. All right, let me talk a bit about some recently proposed actions, and I think many of you will be familiar with the oil and gas methane proposal. There's a long history here, as many of you know, stretching back into the Obama administration. I won't go over all of that, but sort of the key points are that in 2016, the Obama administration issued a final rule, Quad OA, governing methane and VOC emissions from the oil and gas sector, both production and processing and transmission and storage, sort of for the first time combining those two sections of the industry into one source category. In 2020, the Trump administration modified the Quad OA requirement to remove the independent methane requirements and left the VOC requirement in place. And they also decoupled that combination of production and processing from transmission and storage that I mentioned. They also made some technical changes, sort of a procedural set of technical changes as well. That switch in terms of repealing the methane requirements, the standalone methane requirements, was subject to a congressional resolution of disapproval under the Congressional Review Act, which allows Congress to review within a certain period of time final rules and reject them. And that was signed by President Biden last year. So we sort of toggled back to the 2016 rule at that point, and then now EPA has proposed a new rule, both for new and then also existing sources. A lot of significant additional requirements, and I list a few just at a very high level on the slide. I won't go through them all. The proposal that EPA issued last year, the comment period has closed, but the agency did not issue proposed regulatory text with the proposal, which is not required, but it's also very typical. They indicated in the proposal that they would issue a supplemental notice in 2022 with proposed regulatory text and then take public comment again. So they still need to go through that process. The agency has indicated that it wants to finalize this rule by the end of 2022. It may get there. That's very optimistic if they're going to go through this supplemental notice process and take a new round of public comment. This drew a lot of comment. I think something like 400,000 comments were submitted on this proposal. So I think I think 2023 is more realistic for a final rule on this. And then I think many of you are familiar with the sort of the high level, that's an EPA slide, sort of that image there, explaining how the industry, sort of the steps within the industry and how EPA describes the rule and applying to those particular segments. This proposal, I think, doesn't get the attention it deserves given the economic significance of it. So EPA recently proposed, it's got a very long name, but it's really under the sort of the good neighbor provision of the Clean Air Act, the requirements for stationary sources to control, this is seasonal NOx is the key here, but the previous iterations of this program called the Cross-State Air Pollution Rule apply to SO2 as well. This has always been targeted up until this proposal. This set of regulations has always been targeted at electric generating units. It's always been a power plant specific regulatory scheme. It's typically applied to the eastern US. And for the first time now, EPA has said this is, let me back up. This is tied specifically to eliminating upwind contribution to downwind non-attainment of the national ambient air quality standards for ozone. And so the prior iterations of this rule were targeted at the 2008 ozone NOx of 75 parts per billion. This proposal is targeted at meeting this requirement for the 2015 ozone NOx of 70 parts per billion. So the standard has come down, more areas are in non-attainment. So the agency had to go out and attempt to find emissions reductions that were cost effective, and it determined that it could not do that only from the electric power generating sector. So it's now applied more stringent standards to that sector, or proposed to do so. But it's also looking at other non-EGU sectors, and I put a couple up here that may be relevant to folks in the room. Reciprocating internal combustion engines from pipeline transportation and natural gas. And, you know, that's above the sort of the niche app that would apply. And then large boilers in basic chemical manufacturing, petroleum and coal products manufacturing, those are the traditional agency sectors there. So this is recently proposed. The way the current rule is structured that applies to power plants, there's a trading system. So states are allocated budgets. Sources then receive a certain amount of sort of a credit, and then if they emit over that limit, they have to go and find credits from other sources. It's a trading market. It's a separate market for NOx and for SO2. So I think this would work. I think it's proposed to work in quite a similar way, but you see that depending on what state the facility is in, it might be covered for both power plants and other industries, or just power plants, or if it's California, it's just other industries. So it's a complex rule. It's very economically significant. It obviously doesn't apply nationwide because it's targeted at those upwind contributors to downwind non-attainment. So you see, you know, the Northeast and some of the, you know, North Carolina, the Carolinas and Georgia and Florida are not covered because it's really trying to target what are the upwind sources to those states' non-attainment of the ozone NOx. So the comment period on this one is open. Just briefly, the agency has been very busy in the renewable fuels area, and I've got a longer talk on this afternoon, so I'll just go through this at a very high level. But as is required, they've proposed annual volume blending requirements for the renewable fuels program. And this, generally speaking, under the Clean Air Act, this is the program that requires the blending of renewable fuel into transportation fuel. So they proposed annual volumes. You can see an overview of the levels that they propose. They have, there's a separate action where if you're a small refinery, which is if you have 75,000 barrels of throughput a day or less, you're eligible to apply for a small refinery hardship exemption. The agency has taken an across-the-board approach and proposed to deny all pending small refinery exemptions under a theory that all refineries are able to recover their compliance costs. It's called the RIN cost pass-through theory. And so they actually don't bear any hardship from this program. It's sort of a change in position that this administration is taking. So they propose to deny all those exemptions. Those could be finalized today. Actually, there's been some press reports that the agency could take final action on some of those as early as today. They're reconsidering small refinery exemptions that were granted for the 2018 compliance year by the last administration on remand from a court case. They've also extended deadlines. And then the big one, sort of the last bullet point here at a very high level, the way the statute is written, it lays out annual volumes and it allows EPA to deviate from those through various waivers and other authorities. Those sort of statutory volumes, the table in the statute runs out in 2022 because this was passed in 2005. And so the table only extends through 2022 for most types of renewable fuel. And so EPA now has authority to promulgate a rule without the sort of statutory, it doesn't have to depart from a statutory level. It can promulgate them weighing the factors that Congress has included in the statute sort of on a clean slate. So that set rule, and sort of shorthand, the set rule is going to be very significant for this entire program. And it will be interesting to see whether the agency tries to dramatically go up in terms of what it thinks it should be required for blending, and you know, expected in the regulatory document that was issued by the White House for this to be released in May. We'll see if they are on track. This is a very busy area, and I worked closely with these folks when I was at EPA, and they're always busy, but they're particularly busy right now. We'll see if they hit that deadline. Another mobile source proposal recently proposed, it's the NOX heavy duty rule. NOX standards for heavy duty trucks starting for model year 2027 and beyond. Again, very economically significant, $21 through $23 billion in projected costs for manufacturers and another four to nine for operators. We will see if the agency does what they did on the light duty rule, where they finalized a more stringent alternative. They've done multiple proposed options, and you can see they very well could decide to finalize the more stringent alternative here. There's already been pushback from the NGO community that this proposal is too weak. It's weaker than the California standards. It doesn't become effective for another 3 years or so, when model year 2027 vehicles start coming out. So this is an area to be watched. Final rule expected again, projected by the end of the year. We'll see if the agency meets that timing. Switching over to the Clean Water Act, I'm not going to spend too much time on this because John's going to cover this in the next presentation, but a lot of developments going on in the waters of the United States area. This is the regulatory definition this is the definition under the Clean Water Act that defines the regulatory scope of the act. The agency has been tussling, the agency and courts, frankly, have been tussling with this for decades now. The Obama administration promulgated a rule, the Trump administration repealed the rule and promulgated its own definition, which I worked quite a bit on when I was in the agency. That definition was in place for about a year until a district court in Arizona vacated it. The agency did not appeal the vacature, they accepted the vacature. And so what we're stuck with here in the interim is the 1986 version of this definition from the Reagan administration. The agency says they're undergoing a process to promulgate their own definition. That has not been proposed yet, but the intervening sort of wrinkle is that the Supreme Court has granted cert in a as-applied Clean Water Act enforcement case, Sackett versus EPA. That name may be familiar to you because this case went up to the Supreme Court in 2012 on a jurisdictional question about whether an enforcement order was challengeable. This is going up on the merits. And just very briefly, the photo there, you'll see the property that's at issue in the Sackett case. So this is the vacant lot on a lake in Idaho where the Sacketts would like to build their house. And the arrows will show you sort of how that's tied to a sort of the jurisdictional determination. So this is a large lake. The agency said not that this connection brings this in, so there has to be an adjacent wetland to be jurisdictional. The issue is that the agency has concluded that this parcel is part of this larger wetlands complex to the north. And then that wetlands complex is adjacent to a small stream that connects to another stream to this creek that goes into the lake. So it's a very complicated fact pattern. There's mootness questions in this case as well because EPA has withdrawn the enforcement order. So in my judgment, this is a very messy case for the court to start figuring out WOTUS jurisdiction. But they've taken the case and we'll see how it turns out. The court has had a track record of trying to define the scope of the Clean Water Act in these as-applied cases, like Rapanos in 2006, as opposed to kind of reviewing an agency rule on its face, which would be the more traditional way to do it. Very briefly, two additional items. EPA has said it's going to reconsider the most recent NACS review for PM. Right now it's set at 12. Just last month, CASAC, which is an advisory committee that advises the administrator on sort of science issues and setting the NACS, has indicated that a range of 8 to 10 may be more appropriate, and it sounds like a small range that could have significant impacts in terms of which areas of the country are deemed non-attainment, designated non-attainment rather. That was their recommendation. They were critical about how quickly the agency is moving and that they weren't allowed adequate time to fully assess the issue. EPA has said they're planning to propose something by August. Again, very aggressive. Full NOx reviews. Historically, the statute gives the agency 5 years. The agency rarely meets that 5-year window. So EPA is really pushing hard on this one. Again, I think John's going to talk about 401, so I'm only going to mention that the agency is planning to issue a new proposal on the 401 water quality certification requirements. These are the state certification that a permit, that someone who is seeking a permit or license from the federal government needs to obtain in order to get that federal permit. If the state denies the certification, then the federal agency cannot issue the permit or license. In 2020, EPA revised its rules governing this process. A district court vacated those rules. EPA has started the process of revising them. They recently sent over a proposal to the White House for the start of the interagency review process. That's the final step before a proposal is published for public comment. And then just yesterday, the Supreme Court, again, another curveball here, stayed the district court vacature of this rule. So whereas, again, like WOTUS, where the agency was not going to appeal this vacature due to the change in administration because they wanted to have their own take at rewriting these requirements, the Supreme Court stepped in in a case filed by certain Republican AGs, state AGs, and issued a stay of the vacature. So what we have in effect now, until the resolution of this litigation or until the agency replaces this rule through rulemaking, is this 2020 set of regulations governing this certification process. Just see my time here. Let me quickly just talk about enforcement. I think for those of you who work in this space, you'll be familiar with EPA's national compliance initiatives. These are simply areas that EPA has indicated it's going to spend special attention or devote special attention on. And they usually identify these areas for blocks of time. So the most recent ones are shown here. I think none of these are really too much of a surprise. And so we'll see when it's time to revise these. We'll see if the Biden administration decides to change course, but they've also put a lot of emphasis in the enforcement space on aftermarket defeat devices for motor vehicles, also on drinking water issues, especially related to lead. Environmental justice gets a lot of attention, and I think in the enforcement space, we're still seeing how it sort of translates from policy to enforcement. There are some early examples where the agency is indicating that environmental justice considerations are motivating their actions, and I'll touch on those in a minute. So in terms of, I'm sure you all are familiar with the term by this point, but in terms of implications, how is EPA using this policy concept and applying it to enforcement? I think we're going to start seeing higher likelihood of facilities who are near environmental justice communities being the target of inspections, increased inspections, site assessments, and potentially enforcement actions. The agency has said it's going to move at a faster pace for actions that are directly affecting environmental justice communities. I'm not sure we have data to suggest that's actually bearing out, but they have indicated that's a goal. Accelerated timelines for injunctive relief, and frankly, just more of a focus on injunctive relief in settlements. I think we are starting to see that become more of an issue beyond simply just settlements that include penalty provisions. And then, of course, taking a more hardline approach for penalties when the facility is located in an environmental justice. And there are many sort of other presentations this week that go way in depth into EJ and how it applies in various areas. So I won't go too far into that. how is climate change impacting the enforcement approach? I mean, certainly in the past, I think the concept was, well, at EPA, sort of, well, the program offices and the regulatory development folks, they'll take care of the GHG related issues, and enforcement will just focus on what it always has. And I think that's starting to change. It's starting to change with, obviously with the methane rules and other sort of requirements are now kind of becoming more mature, and enforcement is now starting to sort of have a better handle on how to approach those those rules. But you're also now seeing more coordination in the regulatory development process. The HFCs, hydrofluorocarbons, Congress passed a statute directing the agency to conduct a rulemaking to phase out HFCs. Being very general here, there's more details than that, but EPA kind of they promulgated the rule and finalized it last year to carry out that congressional direction. But they also partnered up, sort of the Air Office worked closely with the Enforcement Office on this HFC task force to set up a structure to prevent illegal HFC trades and use of these chemicals. So you're seeing more integration, I think, on the climate change side between the program offices, the ones that are responsible for promulgating the rules, and the enforcement side, the ones that are responsible for enforcing. EPA always issues a fiscal year sort of enforcement results, sort of touting what they've accomplished. This is for last fiscal year. It straddles the Trump administration and the Biden administration since it's fiscal and not calendar year. But I think, you're starting, like I mentioned earlier, we're starting to see indications of how EJ is going to impact enforcement. I think the agency is now much more willing to use its enforcement authority under its emergency authority rather under various environmental statutes like Clean Air Act 303, Safe Drinking Water 1431, RCRA 7003. I think you're seeing much more of a willingness to go to an emergency order more quickly than they have in the past. So in the Clean Air Act example, St. Croix, the refinery down there, was probably the prime example of a very stringent sort of shutdown enforcement order. A few weeks after that order was issued, the operator declared bankruptcy. They also issued an enforcement order to a paper mill in South Carolina for H2S emissions. I would say that was a little unusual, although I think the facts of that instance are unique in terms of the levels that monitors were picking up of H2S beyond the fence line of that facility. But you are seeing this general trend of more of a willingness to issue these emergency orders, certainly under the Safe Drinking Water Act, 1431 emergency orders to localities and water districts. That's really picked up. You are starting now to see RCRA emergency orders as well for waste handling. Some other enforcement results that they touted included, they are still continuing to focus on Superfund cleanups, and I've seen in my practice that Superfund remedy decisions and also enforcement cases are being pushed more aggressively. And then you've got, maybe an indicator of things to come, but under the Toxic Substances Control Act, using authorities like the lead repair and renovation and painting rule. There's a large settlement with Home Depot about Home Depot contractors performing jobs in homes that disturb lead paint. It was a $21 or so billion settlement with quite a bit of injunctive relief with Home Depot. This could be a growth area for the agency as well. So some predictions about where we're going. I've touched on these already a bit. I think continued focus on mobile sources. That's no surprise, just given where the agency has been on the regulatory front and the enforcement front. Tampering, especially aftermarket defeat device focus, I think that will continue. Applicability determinations under NSPS for oil and gas. I think you're starting to see a more sort of, I wouldn't say by the book, but at least a little more inflexible approach from the agency on that. chemicals, like I mentioned, a broader use of TSCA authorities. You have a lot of developments going on the regulatory side under TSCA. I think you're going to start seeing a uptick on the enforcement side as well to kind of match that focus. And again, on the waste side, in January, the agency took a number of actions related to coal combustion residuals at power plants, starting to read its regulations in a much narrower, less permissive way, without going through the rulemaking process on these. And then focusing on those facilities, those CCR impoundments that are in EJP.